for tuning in today. This is super, super important information. I'm really excited to give it out because we help a lot of families with estate planning, but I'm really excited for the opportunity to help other parents like myself, like many of the people that work in our office, help them with planning for, for young kids, right? Estate planning for young parents and what you need to know, because so much of what we do is often lost on the younger generation like ours, because we think that we just don't need to tackle this right now, or life just gets in the way. We have soccer practice, dance recitals, we have school. There's so much going on, and I'm so glad that each and every single one of you tuned in today for this important topic, because what you're going to learn today is information about what you need to do to protect your kids. And that is so important, and you really can't afford not to. And that's why this is really, really important. So let me just tell you what we're not going to accomplish today, and then I'll tackle what we are going to accomplish today. So look, I cannot give you legal advice. I mean, obviously, you're not even before me here. This is just information to get the juices flowing, to give you an idea of what it is you need to do and what will happen if you do absolutely nothing. So this is just legal information, right? This is just an idea about estate planning for you, with the mindset and looking through this with the lens for young children and what you need to be doing now to protect them. So what we're going to discover today is what happens if you don't make it home today. And I think this is such an important question. And I know it's very drastic. Like, what if you didn't make it home today? Because we want to put this off. We want to put off estate planning because we're young, we're busy, and we're not worried about this very important question. So before we dive into anything, I want to tell you what would happen if we didn't make it home today. Next, I want to talk about what basic estate planning tools are required to avoid some of the very, very negative, drastic consequences that'll happen if you don't make it home today. We'll then talk about why it's so, so, so important to name a guardian, how we do that, what a guardian is, and what happens if we don't name a guardian. And then lastly, we'll talk about how to properly leave money for young children. Hey, I'm going to raise my hand as one who has filled out a life insurance policy, beneficiary forms, and put my children's names on it. That is not the proper way to leave our children money, but it's one mistake that so many people do time and time again. So this is for you if any of that stuff interests you and you want to protect your children, if you care about what would happen to them if you don't make it home today, if something happens to you and your significant other, then this is something that you are not going to want to miss. This is also for you if you want to have a plan in place. Like, if you don't even want to know what's going on and don't care, then this isn't for you. But if you want to confront that monster in the closet and tackle it, and they say eat an elephant one bite at a time, this is the place to start. And we are going to talk about just that. You're going to leave today's webinar with actionable steps that you can use and knowledge you can use to get started on fixing this and getting an estate plan in place that truly protects your children. So imagine that you could wave a magic wand, right? And the kids are protected. There's someone who's appointed to be able to take care of your children, the person of your choosing. You have peace of mind in knowing that these important, although difficult, topics and questions have been addressed, and you get to choose the key decision makers for your estate, your beneficiaries, and the people who get to make very important decisions about your children, instead of leaving those really important decisions up to a state court. Before we dive in, let me tell you just a little bit about myself. I'm an estate planner. I'm the owner, founding attorney, and managing attorney of Sheryll Law PC. We are an estate planning and trust and estates law firm here in Eastern Suffolk County, helping people tackle estate planning. The people that we work with have families, they have children, they have a legacy they want to leave behind. They want to take control because it's a responsible thing to do. They don't want to leave these things up to chance. They don't want to leave their kids out to dry, with decisions about their future being made by the state laws and the state courts. And they also don't want to leave this all tied up in court and leave it in ways that need to make it very difficult for their families and the people that'll pick up the pieces when an inevitable, when a drastic circumstance happens. I know and I hope that it's not going to be any one of you in the call. That's why it's called estate planning. We are planning for the unexpected. We want to have this in place and not need it, rather than to not have this in place and need it. Because when that happens, the people that are really getting hurt are your family, the loved ones, your children that you're leaving behind. So, with that passion, I started this law practice. And this is all that we do. I'm a parent myself. This is my wife and I when we were kids. This is us when I was a little bit younger. This is when I started formulating an idea to become a lawyer. Didn't, at this age, want to be a lawyer. I had actually wanted to be a police officer. So here I am. This was me directing traffic and writing tickets for the South Old Town Police Department. But my wife and I got married. And we had our first child. This is Eliana. And this changed my life, right? As it did for all of you on this call. Like, your children are our future, right? From generation to generation to generation, we are one link in the chain that connects the past to the future. And these children are our future. And I don't know about you. Actually, I do know about you. That's why you're on this call, is that you will do anything for them. This is my second daughter. This really shook me awake. My second daughter, Lily, was born premature. She was born premature. This is at 31 weeks. And in this moment, I saw how quickly life can change. Because we all want to pretend like this is nothing bad's ever going to happen to us, because it's just unpleasant to think about. If we even think about it, because we're busy. Like I said before, you have things going on. We have football coming up. We got Boy Scouts, Girl Scouts, everything. You're so busy. I know, because I am too. And if we don't think about this stuff, then it's a big problem. But everything can change on a dime. And I experienced this with Lily, because life and my priorities in life shifted, much like they did with Eliana, but even more so in an emergency situation. Lily was born premature at 31 weeks. And this is her and her sister, Eliana, today. And that was the impetus for me starting this law practice, because I saw how fragile life could be. And it allowed me to get in front of families at a time of need. Now, some of our clients are older and they see this coming. And many of our clients are younger and they're spurred to action, unfortunately, often by a death of an older brother, sister, parent. I want everybody, and my mission here for this firm is to be proactive and get as much information out to people. So at least if you choose not to do anything, you do it knowing what the consequences are. And look, the laws are complicated. Look, you don't know what to do. Like, for example, I mentioned the IRA beneficiaries, or the beneficiaries on a life insurance policy. I've been there. I've been there before I went to law school, before I started this law practice, thinking that was okay. And if you think that's okay too, stick around. We're going to talk about why it's not. Because not knowing your options and not knowing how this all works is a disadvantage for you and your family. Now, the thing is, like everything else, everybody can Google anything and anybody could write anything on the internet these days. So the internet is filled with landmines of incorrect information. But sometimes there's actually correct information there, but it just doesn't apply to you. It's kind of like reading WebMD, right? If you read WebMD, you could go in with a symptom of a cough and come out with a determination that you have tuberculosis. I mean, but you don't necessarily know that that's correct, even though that a cough, it may be a symptom of that disease. And my favorite part of what we do is seeing parents, families, loved ones worry turn to relief, because this is checking a major, major box off the list of things that you need to do to protect your children. And I truly believe this. But if we fail to plan, that is a plan to fail. You are just rolling the dice with your kids' futures if you do not take care of this. So let's dive in and ask that first question. What happens if you don't make it home today. So if we don't make it home today, if you don't have an estate plan in place, what happens is, number one, the state has a written will for you. That will says, and it's not really called a will, but for the purposes of right now, let's call it a will. The state says who gets your money when you die. Now, most of you on this call are married with children. What it says is that your spouse gets about half of your assets, and the other half of your assets go to your children. Now, if you're like me, I am married and I have two young children. I just showed you them before, that picture of Eliana and Lily. They're 7, and Lily's going to be 6 this week coming up. If I pass away, that means my wife is going to get about half. Brigitte will get about half of the assets. And Eliana and Lily, even though they're 7 and 6 years old, they'll get about half the assets. Now, that's incredibly crazy. Like, that's not what you're thinking you want your estate plan to say. I know this because it doesn't make any sense. But I don't know why the government does it that way. That's just what New York State does. It's out of touch. And it's funny because it's out of touch, I believe, personally, of all age groups. Because I haven't even met someone in their 90s that wants that to happen. They want their surviving spouse to get the assets, just like you do, just like I do, right? I want my wife to get the assets. I want her to get them so she can take care of the children. Now, if my kids inherit the money, right, they get half. That means my wife only gets half. And what happens to the kids' money? The kids aren't old enough to even open a bank account yet, right? They're 7 and 6 years old, which means that my wife is going to need to go to court. She's going to need to go to court to become the guardian over their money. And every single year that she wants to spend money out of those accounts for my children, she's going to have to get court approval. Yes, I know that's crazy. She's going to need to get court approval. She needs to have permission on how to spend the money that becomes held in these court supervised accounts for the children's benefit. That's incredibly restrictive on her. So she is unable to access that money to care for my children. And she's only left with half of the assets to do that. And she's stuck going to court every single year to request permission to spend the money and get approval for those transactions. And what's even crazier is the court takes the position, because you didn't seek the plan, that you should have known that this was going to happen and that you intended for this to happen. And since you intended for this to happen, your goal must have been to preserve as much of that money for the children for when they turn age 18. And so what that means is the court's not going to approve money to be spent for things that the surviving spouse, like in my scenario, my wife should be paying for. So if I die and half the money goes to my children, half the money goes to my wife, and she needs to pay for a dance class like the kids are going to today, and she needs to pay for school books, the court is not going to let her take the money out of those accounts lightly. Because the court's going to say, well, it's a tough break that dad died. Yeah, that's horrible. But that doesn't mean Eliana and Lily need to pay for their way in life now. No, Mom, you have money. You have a job. Go get a job. If you don't have one, you pay for it. You're not going to pay for the kids' extracurricular activities. The court takes the idea that they're going to preserve this money, as much of it as possible, for the 18th birthday of that child, which is not how any of us plan for the unexpected death of one of us, right? If my wife passes or I pass, that's not at all what we want. We want our surviving spouse to have access to the money. We want our surviving spouse to have the ability to spend that money for the children. So that's number one. Number two is, if you both pass away in a common accident, which we see unfortunately happen. Both parents pass away. Let's say two parents away on vacation, get in a car accident, kids are home, both parents pass away. What happens? The kids are getting the money, but the kids are getting the money in a court supervised account, just like we talked about, because the state figures, hey, You had an opportunity to make that not happen, and you didn't. So you must have known what the consequences would be. So the court assumes that you wanted to give them all this money at the age of 18. And we're, again, tough break in life, kids, but that doesn't mean it's their responsibility now to pay for themselves. So the court's guiding principle in all this is to preserve as much money as possible for your children. Okay. Again, not the circumstance we want. We want to have access to that money to usually continue the same way that we treat our children, impart the same values that we want to impart in our children had we been there. That is what you need to start to think about, and the state could care less about that. Another really important part of doing this is naming a guardian, because you're going to want to pick who's going to be in charge of your children if something happens to both of you. So that accident scenario, who's going to have custody over your children? Now, look, everybody says, well, everybody will get along, but I'll just pick on my family, right? My in-laws get along, my wife and my wife's parents and my parents, so they get along well. But if the kids, we both passed away and the kids were up for grabs, I know obviously they're both the best interests in mind, right? I don't think either of them would have any ill intent to the children, right? But they would both think that they were better suited to take care of our children. And I know that's the case. And I can't necessarily take that away. But what I can do is I can proactively head that off by naming who we want. That's a very personal decision. Sometimes it's a parent, sometimes it's not a parent. Maybe it's sister, maybe it's brother. Either way, it's really important that you get to make those wishes known. And then lastly, if we don't make it home today, then what will happen is also then we don't have our will prepared. We don't have this. We don't have our beneficiaries' names. So money's going to the children, or go to the children, even though the spouse is still alive. The guardianship piece of it is not taken care of also, but also it's going to get tied up in court for a while, because the kids aren't of the age to be able to represent themselves in court. Okay, so the court will always appoint someone to represent their interests for them, which makes a somewhat adversarial proceeding out of nothing. And I say somewhat because they're not all litigated necessarily, but there are significant checks and balances put in by the court, at least, to protect their interests, have court-appointed attorneys appointed for them, which is a little crazy when we think about leaving money to a surviving spouse, their mother, for example, their father. It just doesn't make sense. So if you don't take care of this, this is what is staring you in the face. This is staring your kids in the face. This is staring your spouse in the face, that this money is going to be chopped up and subject to court actions basically until the kid's age 18. And then what we didn't talk about so far also is, let's say you had a nice life insurance policy and left the kids and wife some money there. And what happened is that, she's got some money, spouse, but the kids then get some also. Well, what happens is the kids aren't able to inherit it until 18, like we talked about. So court supervised account. But what happens when they're age 18 also is they get all that money. So for example, if each of my kids get $500,000 and it's being held in a court supervised account, and there's $500,000 left when they turn age 18, they're each getting a check for $500,000. Here, Eliana, happy 18th birthday, $500,000, right? I don't know about you, but that scares me. It scares me that my young kids at 18 would have that much money in their name. Why does it scare me? Only because of my own experience, that I don't know what I would have done with that money at 18. It certainly wouldn't be wise. A lot of people start to think about this and want to hold that money back with some control until the kids are a little older. It doesn't have to be forever, but college age, 23, graduating college age, or getting married, 25 or 30, completely a personal preference. But for many people, that idea of the court releasing that money at age 18 is very scary. Okay, so now what we're going to talk about is the estate planning basics that you need to have in place to fix this, right? For every family's needs, and how we can go about appointing that guardian for that minor child. And then lastly, we'll talk about how to properly leave money to the minor children. Okay. And this, for most of us, will be, what if something happens to both spouses? What do we want to provide for the children? This is where we're going to dive into that big, big, big red glaring error on many of our estate plans. And I put this there because it is estate planning to think about putting a life insurance beneficiary on, but many of you may not have thought about it that way. And that's naming the kids as the beneficiaries of our IRAs and our life insurance policies, and the problems that can arise from that. So let's first talk about estate planning basics. For the purposes of this talk, I'm going to cover them as if it's the first time we're hearing about this. These are the documents, with the exception of the last one, a set of documents that everybody needs to have. Okay. The last one, and we'll talk about as we move forward, is something that can be used to add on to your estate plan to give it more juice, to give it more protection for you. It can be done in multiple different ways. But let's tackle first the power of attorney. The power of attorney is a document that allows you to appoint someone who can handle your financial affairs for you. You as spouses, husband and wife, don't have this power. Maybe I can call up and pay a bill, and I don't usually find the vendors give me a hard time about trying to give them money on behalf of my wife, Brigitte. But the moment I want any information, to change account status, to get information from them, they won't give it to me. The account's in my wife's name, it's in Brigitte's name. And I am her husband, right? But that doesn't give me any authority to get access to that account. You need to have a power of attorney appointed. Now, you may have come across a power of attorney when you did your home purchase, perhaps, if you bought a house, and that is something that we commonly see. That is a limited power of attorney, right? It is usually limited in nature and non-durable. And what that means is that it is limited to just that real estate transaction, and it terminates, it ends. It's no longer effective if you become incapacitated, which is not at all what we want. Actually, I could pay my bills just fine right now. And if I need help with that, I really need help when I am incapacitated. Like if we had a client on the way home from work, got into a car accident, suffered a traumatic brain injury, did not have a financial power of attorney. And what happened was the spouse had to go to court to become appointed his guardian just to be able to handle his finances. She needed to be able to submit and hire an attorney for a disability claim and to bring a lawsuit against the driver. She had no powers to do that. And also granted all those other powers that we were just talking about, being able to handle finances and all property and income and file tax returns and hire accountants and everything that you need to do, your spouse needs the power to do it. Okay. At another level, we need to think about what happens if something happens to both of you. But at its core, you two, as husband and wife, right, or significant others, don't have the ability to do this. You need a financial power of attorney. The idea of immediate or springing, what that means is that, does it go into effect today while I still have capacity, or does it spring into effect in the future when if I do actually become incapacitated? And there's no right or wrong answer to the way to do this, but I often help people prepare immediate powers of attorney. And the reason why is springing powers of attorney are very hard to enforce. Okay. They're very hard to get a bank, the government, any entity to accept a springing power of attorney. They fight them tooth and nail because of the conditions that you put on the effectiveness of that power of attorney. And what they do is they go, well, how do you prove the person's incapacitated, for example? Well, we want a court order. And that court order is the whole guardianship proceeding that we're trying to avoid. And what guardianship proceeding is how you go about getting someone a financial power of attorney where they don't have the capacity to sign this important document anymore. And that's done through a court system. And like the court system that I was mentioning earlier with the children, you will be in this court system for the rest of that spouse's life. And you will need approval from the court for every expenditure to be scrutinized heavily on how you spend the money. Easily avoidable by getting a power of attorney in place. Okay. The next key core document is a healthcare proxy. coupled with the power of attorney. These two documents are designed to help avoid the need for a guardianship proceeding for your significant other, for your husband, your wife, or your significant other. The healthcare proxy is very similar to the power of attorney. It allows someone to make medical decisions for you when you can't. Okay. So, unlike the power of attorney, which is dealing with finances over here, the healthcare proxy is dealing with your healthcare decisions. The good thing here is that they're all springing and there's no choice. And the law is very helpful there with this idea. And so, springing healthcare proxies are very easy to enforce. Okay, so there's no other way of doing an immediate healthcare proxy. It is only when you can no longer handle your affairs. The law is written that way is because you could sign a power of attorney right now, giving your significant other the ability to handle finances, even though you still can handle your finances. But what you can't give away is your right to be able to handle your healthcare affairs. No one gets to make those decisions unless you are unable to do that yourself. Okay. With those two documents, those two key documents, you can avoid the need for a guardianship court. Now, the good news here is that there are some limited powers in a hospital setting for spouses to make decisions on behalf of the other. Unlike the power of attorney, where there is no piece of it, right? They have no ability to make any decisions. The bad news is it's only in an emergency. It's only in, like, if I don't make it home today and I get a car accident, I'm in a coma and my wife needs to make medical decisions for me. Well, thankfully, I have the power of attorney and healthcare proxy in place. But if I didn't, she'd be able to make those decisions for me while I was in the hospital. But like the client I'm telling you about before, on his way home in a car accident, suffered a traumatic brain injury. He was in the hospital. He was in the hospital and the spouse was able to make his medical decisions because he was in a hospital setting. But then he was discharged to a skilled nursing facility that specialized in traumatic brain injuries. He was transferred to this place in New Jersey. And he lived 3 more years there. Without a healthcare proxy, he was no longer in a hospital. The spouse needed to get permission from the court to make medical decisions for her own husband. And we had to do that through a guardianship proceeding. And every year for the rest of his life, not only did she have to account to the finances, but she had to update the court on all the efforts and all the actions and all the things that she didn't do as healthcare agent. So if you get a power of attorney in place and a healthcare proxy, then that is really, really, really important and an easy way to keep the court out of your lives. Now, if you notice, what we're talking about so far is not even yet what happens to the kids if either one of you or both of you passed away. We're talking about if you're still alive but unable to manage your affairs. So this is really, really important. The next key piece of a basic estate plan for young parents is a HIPAA authorization. And what a HIPAA authorization is your right under HIPAA law. Okay, you see the name posted up on all the doctor's offices you go to allow access to your medical records. HIPAA is a law that makes your medical information protected and confidential. That means if I call my wife's doctor, I have no authority to get any update on her medical condition. I just don't have that power. I can't speak with her doctor. I can't access medical records. I can't get updates. I can't review charts. I can't request a file transfer from one doctor to another doctor. I can't do any of that information. The way we get around that is to appoint each other as HIPAA agents. All right, I've appointed my wife. She's appointed me. Now I have access to her medical information. I have the ability to do all of those things, release information to new doctors, transfer them, get records, get updates. And as her healthcare agent under her healthcare proxy, then with that information, I can make educated decisions about her care if she's not able to do that herself. And that's why HIPAA is so, so important. And actually, it's so important. We do a separate HIPAA authorization because the HIPAA laws allow us to do it. The state laws allow us to do it in the healthcare proxy, so we give HIPAA powers there. And the power of attorney also allows us to have this. So 1, 2, 3 different places we have this access to medical information. And it's so important because if you don't have it, you can get it, but as a guardian, after bringing a guardianship proceeding. The next key document, now we're shifting over towards end of life, and we'll then talk about death and what happens there. At end of life, you need to have a living will for most people, because most people have this idea or belief that if they are in a permanently vegetative state with no chance at recovery, that they don't want to be kept alive artificially. That's what a living will says. Like if I, on my way home today, don't make it home today, I get in a car accident, I have traumatic brain injury, I have my heart stops, I'm out without oxygen, I'm brought to the hospital, I'm resuscitated, my wife comes down, they say Jay suffered significant brain damage. He is never going to recover from this. The only thing keeping him alive is this intubation, ventilation we've given him. What happens? My living will says, don't keep me on those machines. It gives the authority to my wife as my healthcare proxy to say, Jay didn't want to be kept alive like that. He wanted to pass comfortably and timely and not be kept alive artificially by these machines. He wanted to be given treatment that would ultimately provide him with palliative care, right? Care that would just not treat the underlying conditions at this point, but treat his pain. Give me morphine. Give me morphine and pull the plugs, right? That's what a living will say. Now, what it doesn't say is it's not a DNR. Don't be scared off by that now. It doesn't say do not resuscitate me. And it doesn't say do not intubate me. And it doesn't say do not give me intubation or mechanical respiration. Because if any of those things are going to be able to save my life, then that is absolutely treatment that I want, right? That's not what a living will says. A living will only says if that treatment wouldn't prolong my life or would prolong it, but not significantly for me to return to a meaningful life, right, existence. So, for example, I'm on my way home. I have that heart attack. So in the car accident, and my heart stops. I have my living will. It's sitting there, right there in the glove compartment. And they open it up. They see it right there. And it says, do not resuscitate in it if he's in an end-of-life treatment. What that means is that I'm not end of life at that point. They can resuscitate me at the scene. And they can bring me to the hospital and then make those determinations there. But if I had a DNR, different than a living will, a true do not resuscitate, let's say I had that in the glove compartment, and they saw that would say never resuscitate me under any circumstances. And that's not what a living will says, right? A DNR says don't resuscitate me ever. Living will says just don't do it if I have no chance to return to a meaningful life because I'm permanently vegetative state. I have no chance of recovery. So that is a very big distinction. And the same thing goes for a do not intubate order. And we most commonly see these in what's called a MOLST, a medical order on life-sustaining treatment. I wouldn't expect any of you to have that unless you've been through a life-threatening piece before in your life, because it's just not something that we think about. And it's certainly not something that most younger individuals like ourselves would want to have in place. All right, so now we shifted from your lifetime to end of life to death. And we're going to talk about a will. And a will is probably the most common estate planning tool that most people know. And what a will does is choose who gets your money when you pass away and who is in charge of taking care of it and on what terms do the people get it. Okay? So who's in charge of taking care of it? Who gets your money when you pass away and what terms? Now, there's many different ways that you can structure this. And so for the purposes of today's talk, we're going to talk about the most common things. Now, although not everything you can be concerned about, but the most common things parents should be concerned about. The first would be the children. Okay? Remember I said if you don't have a will, the state says the kids get about half the money and your spouse gets about half the money. So the first thing is having a will in place to change that, if that's what you want, and leave everything to the surviving spouse is key number one. Number two is what happens if both of us pass away. So if my wife and I both pass away, we have to now have successor beneficiaries. Beneficiaries is the name of the people that get your money when you pass away. So, for example, if I name my wife, she's the primary beneficiary. If I name my wife, but then I name my children as the successor beneficiaries in case she has passed away before me, then she is the primary and the kids are the what we call contingent beneficiaries. Maybe you saw that when you were filling out your life insurance beneficiaries or your IRA beneficiaries. The key here, though, is when we leave it to the children in our will, we can choose on what terms do we want to leave that money to them. Now, like we were talking about before with having no will, if you just name the children's names here, they're going to inherit it outright. It means, hey, child A, child B, child C, split it in equal shares. That means that child A, B, and C will get it in their name called outright. But if they're like Lily and Eliana are underage, they're 7, they're 6, right? They're under the age of 18, they can't actually inherit the money. So someone, can't be my wife or I, because we've both died at this point, are going to have to go to court to get approved to be guardian. Just like we talked about before, go to court to be appointed guardian to get control over that money. And when they do, they're going to need to go to court every year to get proof or permission and settle an account of how they spent the money and get approval of that. And the court is going to take a very, very, very conservative approach where the sole goal, other than the child's health and safety, is to preserve that money. The bulk of it, all of it, for when they turn age 18. And then last, when they turn age 18, they will get one big fat check for whatever that amount is, all at one time, all on their 18th birthday. So you can change that in your will by, instead of leaving money outright to the children, you can leave it in trust for them. Now, remember I said we would use this word trust. Now, there's a couple ways we're going to talk about it. We're going to talk about it in this context, first with a will, because wills can create trusts. We're also, on the next slide, going to talk about what we call living trusts, trusts that you create today, okay, that you can actually put money in. Versus this type of trust is really not created today because you can change your will anytime up until you die. And so that will, that trust really isn't created until you die and the will is probated. So that's why we don't call this one a living will, because it's not really alive yet. But the other type of trust we'll talk about on the next slide is a living trust because it's created and can be used when you're alive. Let's talk about it here. So if I leave the money to the children in trust, there's a couple ways of doing it. But the major benefit of any different way of doing it is so that way there's no need for someone to go to court to become appointed the guardian over the money. And because of that, there is no need to go to court every single year to have a heavily scrutinized accounting where the sole goal is to preserve the money, all the total amount, and not have any expenditures other than if the kid's going to die if we don't do this, that's going to be avoided. And because you can pick when the money is released out of this trust, then what will happen is it doesn't need to be released at the age of 18. It can be released at an older age, like 23, 24, 25, 26, 30, 35, an entire lifetime. If you're afraid about divorce in the future or creditors or death in the future, what happens to this money? You can leave it in trust a lifetime. Some people even do this for multiple lifetimes. It doesn't need to get that complicated, but at a minimum, you should start to think about the idea of an 18-year-old coming into a larger sum of money. So the way that you can get around that is to leave money to the kids in a trust created by your will. There's a couple of ways to design them. Some do separate trusts for each kid. Some do one big pot, well beyond what we can talk about today. But should you choose to do a will and want to leave money in trust, you can avoid the court's involvement and the guardians and all that involvement with the access to money at 18. You really should think about your choices and how to structure it. But at a minimum, what they both or different structures will do, will allow the guardian to take care of those education and shelter and maintenance and medical needs. And basically anything the child needs can be provided without need for explanation. Now, the guardians you appoint here, okay, they're really called trustees. The trustees that are appointed to take care of the money still have to keep records and use the money appropriately. But instead of having to go to court every year for settlement of that, they keep those records. They can batch them together. When we represent trustees, I often recommend they batch together 5 or so years and then seek approval, right? If you're really worried about this, you should appoint someone that you trust. If you're worried about the person not following your wishes, then that's not somebody you want to think about. Now, because of this trust and your will, the whole thing in its entirety is only effective upon your death. That's because you can change your will and everything we talked about so far up until the time you die, or if you don't have mental capacity anymore. So if you have Alzheimer's, doesn't mean you can't do it, but if you don't understand what you're signing, you can't sign new documents. But we'll keep things simple. You can change it at any time up until your death. Now, what we're going to talk about next then is how a living trust can be added on to your estate plan to help avoid the process that a will needs to go through when you die. And this is where I said that the last document itself, when we looked at our list, the power of attorney, healthcare proxy, living will, HIPAA, and a last will and testament, rounding out the essentials. And a trust being an add-on, right, as something that could give some superpower to your estate plan to help make things even easier. And before we talked about this trust, we talked about how some trusts can actually be created by your will and are not a standalone, separate, sixth piece of an estate plan. Okay, but this one here, the revocable living trust, is a standalone sixth item, sixth piece of an estate plan that you can think about if you want to supercharge your estate plan a bit. And this comes from the process that a will needs to go through when you die. Every will has to go through a court process. I know we spent a lot of time talking about avoiding court. That's why we're talking about this trust right now. Every will needs to go through the process of proving that it's a valid will. There's specific legal requirements for a will. They all need to be satisfied, and they all need to be proven to the court that hears these things. It's called the surrogate's court. Also, you, as the person who's creating a will, has to have the mental capacity at the time that you're signing it to be able to create an effective will. Like, for example, if I don't have capacity, I don't know where I am in place. Like, I don't know where I am. I don't know where I am in time. I'm completely disoriented. I could physically sign a document maybe, but if I have no idea what I'm doing, that's not a valid will. The person has to have what's called capacity, right, to sign a will. So we have to prove that also. And there's a court proceeding for every single will that has to go through. It's called probate. Now, I am a big proponent of trying to avoid probate where you know about it and can do that. And one of the really important places to do that is with young children. Because if the probate process takes 7 to 12 months like it's taking right now, that means that 7 to 12 months where my kids have no access to money. So if my wife and I both pass away and we have a will-centered plan, what will happen is that the kids, whoever I've named as the executor rather, will have to go to court to probate that will. Now, just like I mentioned before, because the kids are underage, the court is not just going to accept that will, it needs to be proven. And they're not of the age, the kids are not of the age that they can just agree that that's a valid will. So they will need to go ahead and have a court-appointed attorney to represent their interest. I've been on the side of this. It's so silly, but it has to get done. I've been on the side of questioning a wife about a husband's will. They're clearly married 20 years, 10 years, whatever it might be. All the kids are theirs. The kids are minors. I do estate planning. I know what they would have wanted, but I'm sitting here asking these questions, dragging this on because I have to do my due diligence on behalf of these kids to make sure nothing foul is going on. But of course nothing foul is going on. A husband and wife would want to leave the money. Spouses would want to leave the money to each other. So that could mean 7 to 12 months where the kids don't have access to money. And that could be very problematic. Many of you may also own a home, and that means there'd be no access to the home. There'd be no way to legally live in the home, sell the home, pay the bills on the home, have access to cash to do any of that. And that's where a revocable living trust can step in. Now, there are a number of different type of trusts, living trusts like we're talking about, but the one I want to focus on today is the revocable living trust. And that's because anything you put inside of it, you maintain complete control over and access to. You can take things out and put things in whenever you want. For example, if I put my house and my life insurance policies and my savings account into there, then whatever's inside that trust will avoid probate, and like a will, can have my beneficiaries in it. A little slight change in vocab here, because the trust is going to choose who's in charge of the trust money. And here it's called a trustee, unlike the executor of a will, but it's the same concept, the person who's in charge. And I get to pick who gets the money and on what terms. And the major difference here is that trusts don't need to go through court to be effective. Unlike the will, that in order to use the will needs to go through a court process. But just like the will, we can choose to leave money in trust for the kid's benefit. When we think about a trust, you can think about it like those little dolls where you take the top off and there's another little doll inside, and you take the top off and there's another little doll inside. You can do the same thing, trusts within trusts. Okay, so that is something that you have an option to do with kids. And I think it's very important to avoid the probate process, is put things into a revocable living trust. Now, last, let's talk about how to properly leave money to your young children. So we talked about why naming the kids outright is a bad idea, okay? Because it's going to force it to go through court. And if you don't like that idea, then you need to think about how to change that. Either you need to do a trust within your will for the children, or you need to do a trust within your trust, like that nested doll. How you design it is completely up to you. We've helped people do just really easy. When they get to be 24. We've done, when they get to be 30. Give it to them all at a stated age. We've also done things where they get percentages, a third at 24, a third at 27, a third at 33. However you want to do it, you can also do that. We've also done incentive-based trust or combinations of all these things. Like, I think it's very valuable for my kids to go to college, right? I think that'd be a wonderful thing. So I have put in my trust for them a way to incentivize them to go to college, meaning that if they graduate college, that they get money faster than if they don't go to graduate college. And then you can also make it completely discretionary up to a trustee. And so, or any hybrid of all these. And what I mean by discretionary is, say the kids never get it, and I want a trustee appointed, my sister, to be the one who is going to be distributing money on their behalf. She never owns the money, but she's in charge of it for their benefit. And then we have a successor, perhaps, right? So any combination of these. So, for example, a common combination would be when the kids are under the age of 18, completely discretionary. The trustee gets to choose the person that you've chosen, who's good with money and who knows your values and knows your kids and loves your kids and is going to take care of your kids. They're the ones that get to make the decision under the age of 18. And then when they're between age 18 and 24, let's say, it's discretionary with some money coming out and some incentives. And then after that, it's percentages. Or after that, it's a complete distribution at 24. There's different ways to structure it. It's not all or nothing. Now, just a word, though, about that life insurance policy, the IRA beneficiary form that we talked about. If this strikes a chord with you and you go and take care of this and you don't update the beneficiaries on your life insurance policy, which still have your kids named, and you don't update the beneficiaries on your IRA, which still have your kids named, those things will go to the kids and have to go through a court supervised account. Why? Because the beneficiary designations on those IRAs and on those wills and on any account for that matter, a transfer on death, a joint account, right? Anything where there's another name on it or there is a beneficiary on it, will not go through your will, and it will not go through your trust if it's not in your trust, right? So you need to update those, whether you decide to do a will or you decide to do a trust and a will-centered plan or a trust-centered plan, you need to update the beneficiaries then on the IRAs and the life insurance policies, because those things preempt whatever you put together inside of this estate plan. So if you do a will and we don't change the beneficiaries, the money is going to go to the kids outright versus in the trust that you created for them. So that is very, very important. It's such a sad thing to see when that happens. And it's also even sadder to see when we don't have an estate plan in place, something happens to both parents, and then the money ends up going to the kids outright because they thought they did the right thing by having beneficiaries listed. And these financial advisors and accountants, the financial advisors and life insurance people that sold you this stuff, they don't really necessarily care. They made a sale. I don't mean to speak bad about them, but they have a lot of cases. They have a lot of people. You asked them for one thing, they did one thing. That's all that they were able to do. They're not able to help you with a will. They're not able to help you with a trust. And so unless they're going way out of their way to take that stance of going above and beyond, then they are not really doing this piece of it a service for you. And you are unfortunately feeling secure about something that you're not really secure about. All right. Now let's talk about what you should do next, because we tackled a lot today. Look, if you have nothing in place or have something, think about how your current situation is working in the worst case scenarios, because that's what we're here to think about. We're here to think about what happens if we both pass away. I know we kept saying that today, and it's such a strike, such a hard chord to strike, but that's what we're trying to figure out. I know it's a hard conversation to have, but that's what we owe our children to plan for, right? We need to plan for it. We need to consider their ages and their needs. Different children have different needs, so sometimes we don't want to treat everybody equally. And we also need to see how we feel about access to money and who is going to be in charge of taking care of these important decisions. You also need to seek advice then on how to properly plan for your family. We've talked about at least 6 different estate planning documents and some pitfalls with some common tools like trusts, like the life insurance policies and IRAs that can create a problem. And if everything is not working together perfectly, you're leaving your kids at risk. So you need to seek the proper help to get this done. So far, you've discovered today then is why advance directives are so essential to the estate plan, and how they are so important to making sure that while you're still alive, right, that you and your spouse have access to each other's assets and can make medical decisions for each other. Power of attorney, healthcare proxy. We also talked about the living will and how that can deal with end-of-life treatment. And we also talked about HIPAA and the importance of access to medical information. We then talked about how to appoint a guardian for a minor child in your will, naming the person who's going to have custody over your children to prevent court intervention and to prevent infighting among your family that all have your children's best interest at mind, right? But have a difference of opinion on what that means. And by making that wish known, you can avoid a lot of the heartache that can happen between competing sides or factions of the family fighting for your children. And lastly, we talked about how to safely leave money to children, whether that be in a trust within your will, which then needs to go through probate, or avoiding probate altogether, creating a revocable trust, putting money into it, your assets into it, and then leaving it in trust for your kids and putting beneficiaries in that trust agreement. And one thing I often hear from people, and it's sad to hear, is that, well, I don't really have anything yet. I don't own my home. We have a mortgage on it. Stop right there. If you have a mortgage on your home, you own your home. You bought that home. All you have is a debt. You have a debt that the bank secured against the home. The deed to that house is in your name. And for many of you, you might be sitting with a house you bought pre-pandemic that went up significantly in value. And your debt might be, let's say, $200,000 on a $300,000 house you bought pre-pandemic. That house is now worth $500,000. You have equity in that house that you need to protect for your children. You own that house, right? And you can do something with it. So if we get one thing out of the 50 minutes we've been together today, it's this. I hope that you know that you can protect your children from the courts making life-changing decisions for them. You take control over this. You keep the court out of it. You don't let these defaults of whatever the state says and assumes you know about happens if you don't do anything. You know your options and you take action to protect your future. That's your children. So if you are looking at this and thinking, whoa, that's a lot. This needs to get done. What do we do next? You are right on the right path because we have to protect your kids. So what we've designed for you is our kids protection section. Now, this is for you if you have a family and you want to protect your money for your children and you have minor children and your estate documents are either never done or outdated. What we're going to do is go through a 20-minute virtual meeting together, one-on-one, right? One-on-one with a member of our team and you, or one-on-two. Your spouse should be a part of it. And during this, we'll discuss your specific family dynamics and discuss your desired goals to be able to tailor everything we've talked about today, which is a lot of information, down to a recommended estate plan for you. Exactly marching out the items that you'll need to do in order to accomplish the goals and objectives and concerns that you have for your family. And we'll also provide you with resources that go beyond today's call to be able to help you take the next step to protecting and preserving your family's future. Now, at the end of this, you will have an idea of what a specific plan might look for you. Now, you're not going to know all the details. That can't be done, of course, in a 20-minute virtual call. But by having that back and forth one-on-one, we can talk about exactly how we can help you. And at the end of that call, you can know exactly what the first step is to tackle these difficult issues that you might be procrastinating on. Now, at the end of this time, we'll have talked through your goals and wishes, talked through your specific family circumstances, and you'll be informed about how we can help you. Now, you should see a link pop up where you can schedule this phone call to discuss the recommendations that we'd have for your specific circumstance. Now, if I didn't say before, I'll tell you again now, it's completely complimentary. So you've started this idea of learning about this. Now, take the next step. Take action, because this could happen anytime to any one of us. It scared me to action. It scared me to starting a practice where I can get this message out to help other people realize that at any point, we're never guaranteed tomorrow, and that we need to be responsible and take care of our children and leave everything behind for them that accomplishes our goals, our values, our wishes. Because if this happens, this plan needs to be used. We're not going to be here to raise them. So it's so important. Courtney, I'm going to open up the floor now to the Q&A. If you have any questions, go ahead and put that into the chat. Into the questions section. And I think, Courtney, you may have some questions already lined up. Courtney?
Yes. So we do have two questions put into the chat. One was, at what age should a child be able to be allowed access to their inheritance?
That's a really great question. And there's no right answer that I can give that to you, because that's a personal decision that you and your spouse need to think through. And an estate planner, like the ones we have at Sheryll Law here, can help you navigate that discussion, because there really isn't a right answer to that. We've had many clients say, I just want to give them at age 18. I just give it all out right. I've had clients, and we've all had clients that had people want to put this out forever because they don't want a divorce to chop up this money, or a death for it to end up in in-laws' hands where they don't even know yet, because it's not even a reality yet. And so this is incredibly personal. Somewhere in between, we have people put it at 24 because they think, oh, they've graduated college, 27 because maybe they're getting married, 30 because it's, child time. It's really up to you, but the key is that you think it through, that you have that conversation with your estate planner, and then that actually gets into your estate plan. But certainly at a minimum, you got to hold it until age 18 to keep the court out of it, so that we don't end up having to have a court-appointed guardian needing to be appointed.
Okay, perfect. And we have time for one last question. So, can you leave money to just their kids and not a future spouse or someone else that
Absolutely. So that's it's a common concern. I think many people start to think about this because of the world that we live in now, higher divorce rates, as well as judgments and creditors, and it's a very litigious world we live in now. The way you can protect this money for your family is to leave it to them in trust for their lives. Doesn't mean it's locked away from them for their lives. Usually, what we'll end up doing is saying, it's a trust for my children. And then when they're under the age of 30, let's say, right, where we don't want them to have control yet, we have someone else named as trustee, and they can spend that money for those children and those children only. Those grown adults pay for college, help buy houses, weddings, all that stuff. And when they get to be age 30, hypothetically, right, they get to be age 30, then they get to be the trustees. And as long as they keep the money in the trust and only write themselves checks when they're going to spend this money for whatever they need, and the bulk of the money stays inside the trust. Okay, so for example, they have $100,000 left and they want $5,000 for a vacation. They leave $95,000 in the trust, and then they go and they get in a car accident while on the vacation, and someone wants to sue them. They can't go after the other $95,000. They can't go after the trust money. So the way you can do that is by leaving it to them in trust for life. Okay. Again, a very important decision that needs to be thought through completely, more than we can accomplish in this call. But that's how you do it. You leave it to them in trust for their lives.